Okay, everybody. Well, welcome to our Zoom meeting today. I'm going to give you my short intro to our speaker, and then I'm going to turn it over to him, and Matt will go ahead and tell you a little bit about him. But just to lay the ground rules here, he's going to give us the presentation. This is being recorded, and at the end of the presentation, I'm going to stop the recording, and that's when we're going to take questions and answers. Okay. The reason being is that we want to make sure that the presentation is whole, that Matt gets a chance to go ahead and give all the information so that that can be promulgated. You can have a copy of it. I can actually post it on Facebook, etc. And then when we go to the Q&A, because there may be specific questions that may end up with a little bit problematic in the question or the answer, that's why we're not going to record it. Okay. So just to give you a little bit of background, I've known Matt for a number of years, and how I know Matt is that I was standing at the bar of a golf course. What a surprise. And Matt's dad, Mark Troiani, who's one of my classmates and a friend, this was at one of our Naval Academy reunions, walks up to me and says, "Hey, Mark, you still in real estate?" And I said, "Yeah, actually, why?" He goes, "Well, my son's a settlement attorney up in Northern Virginia. You think you can talk to him a little bit and maybe give him some business?" And I said, "Absolutely." So Matt and I met, and my rule has always been I don't mind if a classmate or a good friend asks me to help a family member out. That gets them in the door. What keeps them in the door and part of the family is to do a good job. And so I talked to Matt, was very comfortable. Matt has done a great job for me when he was a settlement agent. And but with that, I'm going to turn it over to Matt so that he can tell you a little bit more about him, and then we're off and running on the briefing. Okay, Matt, it's all yours.
Thanks again for the invitation and opportunity to present, Mark, and thank you all for your attention. My name is Matt Troiani. I am Senior Counsel and Director of Legal Affairs at the National Association of Realtors. I was in the settlement business until about 7 years ago. I moved over and I was Chief Counsel and Vice President of Professional Development for the Northern Virginia Association of Realtors. So those of you in the region, I helped work on those standard forms and ran our education and code of ethics teams there for about 5 years. And then about 2 years ago, I moved over to the National Association, just in time for all the fun. So I'm pleased to be able to join you all today. I really do love education. Mark, actually, would you mind giving me the ability to share my screen? I'm going to
Sure.
go and I can pull up a presentation.
Okay, come on.
Please, we will allow plenty of time for questions, but I may answer a lot of the questions that you might have as a part of the presentation. But if you want to put them in the chat, if you're worried about forgetting them, otherwise we can save them for the end, and we'll have plenty of time for all of that.
You should have sharing now.
I do. Hopefully, you all can see this. Okay. So, one of the things that I would just want to kind of level set expectations here is don't worry, I'm not going to, bore you with 5 years of legal procedural history or anything like that. But it is important to talk a little bit about how the settlement came about so you have some context as to why we entered into it and what our goals were in considering a settlement. I'm going to spend most of the time talking about the practice changes. And we'll talk a little bit about class notice because you might have already seen class notices did start going out on August 17th. And so you might get questions from previous clients, consumers, neighbors, family members, things like that. And so to tell you where you can send them to get information and talk a little bit about our resources. One of the things that I said at the outset is that it's not like August 17th came and went and this was just one and done. NAR is committed to continuing to support our members as they navigate these changes. That includes providing education, resources, tools to help you have the conversations with consumers and help you navigate the changes. So, the settlement. So, just a little bit of background. Starting in March and April of 2019, there were two class action lawsuits that were filed. The first was filed in the Northern District of Illinois. That became known as the Murrell case. That pertained to a class of sellers in 20 of the largest markets across the country. A month later, there was a copycat lawsuit that was filed in Missouri that became known as the Sitzer or Burnett case. What both of these had in common um, is that the plaintiff's theory of the case was that NAR's rule of compensation. This is a model MLS rule, which all Realtor Association MLSs had to have, which said that if you were a listing broker or agent and you put a listing in the MLS, you had to disclose how much, if anything, you were offering in the form of compensation to other cooperating brokers. We didn't say how much that had to be when we were historically it was understood it could be as little as a dollar or a penny. And in fact, last year when we were asked if it could be zero, we said yes, it can be zero. It just has to be disclosed. And the reason why it's being disclosed is not because based off of like buyer agent behavior, that buyer agents aren't going to show your property, because we already have rules in place which prohibited that. The importance of the disclosure is so that the buyers can make the informed decision as to whether or not they can write an offer on the property and still get the representation that they want. Now, despite our best efforts, we defended this rule in court for about 4.5 years. And in October of 2023, we went to trial in the Sitzer and Burnett case. Remember, this is just the Missouri case. It went through the process a little bit faster, probably because discovery was a little bit more narrow geographically and because the judge moved it along. Now, after an 11-day jury trial, a jury deliberated and came back and found NAR liable for antitrust damages, along with two of the largest corporate franchise companies. Now, we are not here to relitigate that whole thing. We announced at the time that we would appeal if our post-trial motions were not granted. We believe the court made significant errors of law and fact, which kind of directed the jury outcome. But in the meantime, 24 copycat lawsuits were filed across the country against an increasing list of brokerages, multiple listing services, and state and local associations. So while we're going through these post-trial motions, we're getting ready for an appeal. These 24 copycat lawsuits come out there, and we're hearing from the industry. Even if we win on appeal, we're just going to go back and get a new trial. And we're not going to, there isn't any way to win, because in the meantime, we have all these other costs. There's uncertainty, there's ambiguity out there. So we need to find a path forward. So on March 15th, we announced a proposed settlement agreement that would end litigation of all of these cases nationwide for any home sellers related who brought claims related to broker commissions. Now, the settlement agreement has received a preliminary approval from the court, but it has not received final approval. Final approval is scheduled for a hearing on November 26th. That's the Tuesday before Thanksgiving. But the court did very quickly grant our motion for preliminary approval and has otherwise approved the other settlement agreements in these cases. So in considering this settlement, we needed to determine what were our goals? Well, of course, number one is we wanted to make sure that we got a release. There's no point in entering into a settlement agreement unless you get a comprehensive release. So we were able to negotiate a release of all state and local associations, realtor-owned MLSs, over 1.4 million members, and the vast majority of member brokerages. The plaintiffs would not budge on certain brokerages that had more than $2 billion in residential transaction volume in 2022. But we did create a mechanism for those to opt in to the settlement if they chose to do so. But that was just for the brokerages. We did get a release for all of their salespersons who are independent contractors. So number one goal is we get a release for as many as possible. Number two is that we wanted to preserve consumer choice. We defended offers of compensation as being good for both sellers and buyers. For sellers, it gives them an opportunity to choose to promote their property to the broadest range of prospective buyers, because we know buyers are already cash constrained. Many of them are already struggling to save up for a down payment and closing costs. To add To add broker compensation on top of that could become cost prohibitive. So by putting the property out into the broadest pool of prospective buyers, that increases demand and increases the likelihood that the seller is going to get the best offer on the property. And of course, we believe that that system benefits buyers because they still want representation in what is probably the most significant financial transaction in their entire lives, but may not be able to always afford to pay for it out of pocket. So we wanted to make sure that that was still an option for consumers. Now, the line in the sand from the plaintiff's attorneys was that it could not be in the multiple listing service, that they believed that offers of compensation in the MLS led to steering by MLS participants. We dispute that characterization, but this was a compromise in order to get through the settlement. And then the third goal was to make sure that we continue to preserve the access to the dream of home ownership for all. And with this settlement agreement, we believe we've been able to achieve all three of these goals. So some key updates since March 15th. We continue to post new and updated resources on facts.realtor. I'll be mentioning this many times, but go back and check this website out. It is a wealth of resources. We've put out written buyer agreements 101, compensation and disclosure statements, broker to broker agreements 101. We have about 115, 116 FAQs on there that help navigate through these changes and explain everything. We have 14 or 15 short videos that explain all of this. There's a broker slide deck that brokerages can use to train the agents to talk to consumers about these things, and we continue to expand consumer resources. We've got one-page fact sheets for home buyers and sellers. We've got a consumer guide to written buyer agreements, to offers of compensation, all kinds of consumer-focused resources that you all can provide to your prospective clients if they're asking about what does all of this mean. One of our concerns with all of this is that if offers of compensation are moved off of the MLS, is that going to impact the ability of buyers to get financing? And we're pleased to share that Fannie Mae, Freddie Mac, and FHA have all said that for now they are going to continue to treat seller payment toward buyer broker compensation, whether that is direct payment by the seller to the buyer broker, whether that is a portion of the listing broker's compensation to the buyer broker, or seller concessions that the seller agrees to give to the buyer that the buyer applies towards buyer broker compensation. All of those are going to be considered not interested party contributions, therefore not subject to those caps that you sometimes find on seller concessions. So you may have experienced this before where that maybe there's a repair credit or some kind of concession towards closing costs, and the lender comes back and says, well, these are the only qualifying charges, otherwise we can't apply all of it. Here, we're saying that seller payment of broker compensation is not subject to those limits. We, of course, were also concerned with the VA's historic prohibition on veteran buyers paying anything towards compensation for representation. We were very concerned about the potential impacts that would further disadvantage our veteran service member population from being able to get representation in transactions. We believe and we know that they have earned that benefit, and we want to make sure that they are not further, blocked out of representation in a transaction, especially when, as you all know, sometimes they're flying, moving from halfway across the country or halfway across the world. They need that local representation and knowledge. So on June 11th, the VA announced that they were temporarily lifting the ban on veterans paying anything towards their buyer broker compensation. That went into effect on August 10th. That has been lifted indefinitely until they decide whether to go through the formal rulemaking process. The practice changes went into effect on August 17th. I've got to change the tense of that sentence. My apologies. All MLSs, we recommended implement the changes by August 17th. Realtor Association-owned MLSs must implement the changes in order to be compliant with NAR policy. Non-realtor association-owned MLSs, like broker-owned MLSs, did have the ability to delay implementation for 30 days under the settlement agreement, but we strongly encourage them to use the same date so that there's consistency and predictability, and so that the members wouldn't be subject to one set of rules while the MLS had another set of rules. That just creates uncertainty. Class notice did start going out on August 17th. And like I said, the settlement is subject to final court approval in November. So why is that August 17th deadline so important? Why, if the final approval isn't until November, why are we implementing the practice changes now? Well, August 17th was the earliest date upon which the plaintiffs could start sending out the class notices. The class notice is important because once the class notice starts going out, that's what ends the release period. You can't release people from things that haven't happened yet. So the class notice date is the final date of the release going back through the statute of limitations period. And so we needed to get the practice changes in place by August 17th. That way, everybody who's complying with the practice changes going forward are going to have the protection of the settlement agreement, even though there is not final approval until later in the year. For those who are more visual learners, there is a timeline that we have here. Would encourage you all to check this out. This is also available on facts.realtor, and it shows you the significant dates from March 15th through November 26th. All right, so this is the moment you all been waiting for, the practice changes. What does all this actually mean? So there are most of the bandwidth has been around the offers of compensation and written buyer agreements, but there are some important changes to listing agreements as well. And so I'm going to go through all three of those. So again, effective August 17th, offers of cooperative compensation are prohibited on MLSs. This includes all listing types, even though the underlying lawsuit only pertained to residential sales. The settlement agreement requires that all offers of compensation be removed from MLSs, regardless of listing type. That's residential, commercial, rentals, vacant land, multifamily, new construction, etc. Of course, MLSs are permitted to have listing broker and listing agent contact information on the MLS. You can put a link in the MLS if your MLS policy allows it. You can put a link in there to the brokerage's website, but you cannot put a link in the MLS that goes directly to a page on your website, which includes a listing with offers of compensation. Has to go first to like a general landing page or contact page. I've heard every version of this. Oh, can I put like call listing agent for compensation and agent remarks? No, you can put call listing agent. You just can't say anything about compensation, cooperative compensation, commissions, nothing like that. For those of you that are in the Bright MLS footprint, you've probably seen that they've removed all compensation fields. We'll talk a little bit about seller concessions and how that works here in a moment. But offers of compensation do remain an option off of the MLS. Like I said, we fought to preserve that as an option for consumers. When we talk about offers of compensation, we're also talking about two separate things. What might be historically known as a portion of the listing broker's compensation is one option if that's something that's permitted under your listing agreements. But another way of thinking about it is the seller offering to pay the buyer broker directly. That is permitted under Virginia law if the parties agree. And that is something that kind of gets to, I know that some people have been talking about disconnecting compensation and things like that. So the seller agrees to pay the listing broker and then authorizes the listing broker to advertise the seller's willingness to offer compensation to buyer brokers directly, not as a portion of the listing broker. Those of you who are familiar with the NVAR forms, for instance, I believe that's the route that they've gone, that it's no longer a sharing a portion of the listing broker compensation. There is separation now. Consumers are going to continue to have choices regarding their real estate services. So, for example, these are the places where listing brokers under the settlement agreement may advertise offers of compensation. This includes on the listing on their own website. for their own listings, not for anybody else's. Signs and sign writers, flyers in the property, social media posts for your own listings. You can text, email, and phone call and make calls to your network, or you can respond to inquiries from other brokers if they're asking. But you cannot use MLS data or IDX, the IDX feed to create, facilitate, or support any platform for offers of compensation from multiple brokers. So I've heard other versions, hey, can we bury it in the disclosures in the MLS or the documents in the MLS? No, you can't do that. If your MLS has like an integrated showing service or scheduling service or lockbox, you can't put those in there either. But just about every other, means off the MLS, if the seller has authorized it, you may advertise offers of compensation. Just as a note, if it is something where it is a portion of the listing broker's compensation, and that is a practice that you are still doing, you probably will need to memorialize that agreement in writing with a prospective buyer broker, because it is the MLS rules that made offers of compensation enforceable by bringing the buyer ready, willing, and able. Now that they are off of the MLS, you're going to probably want to memorialize that in writing, some form of like a broker to broker agreement or broker letter or something like that. We have some guidance on what that can look like on facts.realtor as well. So one thing that we will note is that concessions by the seller may be advertised on the MLS at the MLS's discretion. This is not a mandatory policy, but MLSs do have discretion as to whether or not to implement this. For those of you who are in Bright, it is my understanding that Bright is allowing like a yes/no field, that the seller is indicating a willingness to consider offers from a buyer which ask for seller concessions. Yeah, the only limitation in the MLS is that those concessions cannot be limited to or conditioned upon the retention of or payment to a cooperating broker. You can't say seller is willing to offer like X for buyer broker, for the buyer to apply for buyer broker compensation or representation. That still gets us around the compensation element, and that has to be, that cannot be in the MLS. Now, one of the things that we've been receiving feedback on is that how does this work then in the purchase and sale contract? Because that's where the seller concessions ultimately have to end up to be enforceable between the buyer and the seller. The forms will typically say something like seller is going to credit buyer, X at closing. But what we have heard from the lending community is it would be helpful if the buyers state in the contract how they're applying, is it's not in the MLS anymore, it's in the contract, state how they're applying those concessions. So for example, buyer or seller is going to credit X to buyer at closing, buyer is going to apply Y of that towards closing costs, and buyer is going to apply Z towards buyer broker compensation. This is going to help the lender determine how much of those concessions are considered interested party contributions subject to those caps, and what is not an interested party contribution. So that's one of the things that one of the feedback we've gotten from the lending industry is it can't be in the MLS tied to buyer broker compensation, but it can be specified in written instructions to the lender or in the purchase and sale agreement. Even if the seller is not offering compensation or advertising concessions, the buyers still may ask the seller to pay as a part of their offer to purchase. That is not a violation of Article 16, Standard Practice 1616. Standard Practice 1616 says that a realtor working with a buyer cannot interfere with the relationship between the seller and the listing broker or hold an offer hostage while they negotiate compensation. But if the buyer directs them to, since your written buyer agreement, which we'll touch on here in a little bit, says that, hey, buyer is going to be required to compensate the buyer broker. If the buyer cannot afford to pay for that, then they can ask the seller to pay either to give concessions or to pay a portion or all of the buyer broker compensation in their offer. That is okay. And that's one of the areas where we get a lot of questions now, is that I've got my written buyer agreement. It says that this is the compensation amount. I know my client can't pay that. And this is where you talk to them about how you can go about making their offer financially still work for them, get the representation that they want, even where the seller has not advertised any compensation or concessions. Of course, the code of ethics always applies to realtors. So Article 1, protect and promote the interests of your client, put your client's interest first. Article 3, ascertain whether or not there is any compensation. Article 9, get it in writing. Article 10, provide equal professional services. Article 12, be honest and truthful in your communications. Mediation and arbitration of commission disputes still exist. Article 17 is not going anywhere, and procuring cause disputes may still arise and be arbitrated. And if you have specific questions on how all that works, I'm more than happy to address it. So moving on to the listing agreements. Just 2 requirements for listing agreements. They must state conspicuously that broker commissions are not set by law and are fully negotiable. And 2, they must conspicuously disclose to sellers and obtain seller approval for any payment or offer of payment that a listing broker is going to make to another broker or representative acting for buyers, and specify the amount or rate of such payment. So if you are going to advertise any offers of compensation or any seller concessions, then there needs to be some approval in the listing agreement for that from the seller. Now, written buyer agreements, that's our last significant practice change. Now, I think that, actually, Mark, is there anybody on this call that is not in Maryland, DC, and Virginia, to your knowledge?
No, I think everybody is
Okay.
here, part of Maryland, DC, and Virginia.
Thank you for that context. I think that, the important thing to understand here is that, in those 3 jurisdictions, we've had written buyer agreements for years. And I kind of took it for granted back when I was at the Northern Virginia Association. I just kind of assumed that was consistent across the country. But when I got to NAR, I realized that as of this January 1 of this year, there were only 18 states that had written buyer agreements established by law. Now, since the settlement, that is now expanded to 25 or 26. So there seems to be a movement in that direction. But we've long encouraged written buyer agreements to make sure that there is consumer disclosure and understanding of their relationship with the broker. But I think for your area, this is something that there might be some changes or tweaks, but for the most part, it is not. This is something that you all are already familiar with because you've been doing it for years. But just when we talk about what NAR's requirement and the MLS policy requires, written buyer agreements are required for somebody working with a buyer and touring a home. And what does that mean? Working with a buyer means an MLS participants who provide brokerage services, including identifying potential properties, arranging for a buyer to tour a property, negotiating on behalf of the buyer, writing and presenting offers. Now, that is what it means to be working with a buyer. But remember, the second trigger is that it has to be prior to touring a home. Just marketing your services or even just sending like listings that buyers might be interested does not necessarily trigger the written buyer agreement requirement. But if you're, but once they respond and they say, yes, okay, we want to go see this home or want to tour this home, then you're going to need a written buyer agreement. This does not apply to like open house situations. You're hosting the open house, we would consider that even if you're there to prospect for potential buyer clients, and I know that a lot of people host open houses for that reason, but while you're in that open house, you are acting for the seller. You are helping the seller sell that house. And at the very least, even if you're not yet working with those buyers who come into the open house. Let's think about this from the consumer perspective. A consumer does not, attend an open house with the expectation that they're going to be forced to sign a written agreement just in order to walk into the house. So we want to be very clear, open houses, that does not trigger the written buyer agreement requirement. Now, if you're affiliated with a listing brokerage, and the buyer, an unrepresented buyer comes in, Virginia law may require that you give an unrepresented party disclosure. That doesn't change, but we just want to be clear that the written buyer agreement requirement doesn't apply just because you're hosting an open house. So what is touring a home? So touring means when the buyer and or the MLS participant, the realtor at the direction of, or somebody at the direction of the MLS participant physically enters the home. I've heard almost every version of this, right? Okay, I just opened up the lockbox and I opened up the door, but I didn't go in. The buyer went in. I didn't give a tour of the home. No, you've provided access. The buyer went in. That is a tour. Or the buyer's out of town, and I physically went into the property to do like a FaceTime or a video tour or something like that. You're still physically in the home. You need to have a written buyer agreement in place with those buyers. That does not apply, of course, to like video tours provided by the seller or the listing broker. That would be completely separate. But if you're working with a buyer, you're physically in that property or they're in that property, you need to have a written buyer agreement. What does a home mean? This is what happens when you get lawyers involved. Everything gets really complicated. We got to define everything. It needs to be signed before touring a home, unless state law dictates an earlier time. Do remember, at least in Virginia, I think deep core has muddied the waters a little bit on this, but once you are working with a buyer and they are giving the subjective intent that they are interested in buying or selling property, you do need to have a written agreement with them. But for NAR purposes, it is before touring a home. A home in this context is a property with 1 to 4 residential dwelling units on it. While the offers of compensation being removed from the MLS applies to all types of listings, the written buyer agreement requirement only applies to residential sales. Remember, it's written buyer, not written tenant. And that it doesn't apply to multifamily, commercial, vacant land, things like that. Of course, you still must comply with applicable state law regarding requirements for agreements. So what must be in this written buyer agreement? There are 4 things. There must be a specific and conspicuous disclosure of the amount or rate of compensation that you're going to receive or how that's going to be determined from any source. That could be the seller, listing broker, the buyer, or some combination of those. The amount of compensation must be objectively ascertainable and not open-ended. It can't be, well, whatever the seller or the listing broker is offering. It can't be a range. It must be like a defined amount or rate, so that it is clear to a consumer what it would be just by looking at the agreement. There must be a term that prohibits the participant, from receiving compensation from brokerage services for any source that exceeds the amount or rate agreed to. And it must be a conspicuous statement that broker fees and commissions are not set by law and are fully negotiable. But otherwise, NAR policy is not going to dictate any of this. These types of agreements are defined by what is complies with and is permissible under state law, what the brokerage is willing to provide, and what they negotiate with the consumer. So there must be an agreement that includes those 4 terms, but just about everything else is on the table, exclusive or non-exclusive. We don't do transaction brokerage here in this area, but there are like limited services, designated agency, dual agency. You could have an independent contractor agreement that's basically like a showing agreement or, a one-time touring agreement or something like that. As long as it complies with state law and includes those 4 things, everything else is permitted, and NAR policy is not going to dictate that. So we're not dictating the nature of the relationship, the term of the agreement, the services to be provided, and certainly not the compensation. So I'm going to spend just a couple of minutes on class notice, and then we'll open it up for questions. I see a few in the chat already. So class notice is it's a communication that is sent out to all class members who would be bound by the proposed settlement. This is the proposed class. All persons who sold a home that was listed on a multiple listing service anywhere in the United States where a commission was paid to any brokerage in connection with the sale of the home. That's a big class. That is a lot of people. It is nationwide. So the class notice can come in a variety of forms. You may see, you all probably seen this before. You get like a postcard or something in the mail. Maybe you got one from like a credit card company or a cell phone carrier previously. You might see them on like billboards, radio ads, internet ads, things like that. Those are all permissible, but what they're going to include is information regarding the litigation, the settlement, the definition of the class, the opt-out procedures. This is an opt-out settlement, meaning that if a person takes no action, they are going to be considered part of the class. If they want to preserve any legal rights to pursue their claims separately, they have to affirmatively opt out. And if they want to be considered eligible for compensation as a part of the class, they do have to file a claim. There's information on the requested attorney's fees and incentives to the class representatives, the objection process, and that final date, November 26th, for the final fairness hearing. They did start going out on August 17th. We've been able to confirm that. Our suggestion would be, because you might get questions from previous clients, from customers, prospective clients, family members, neighbors, friends. What to do in response to a class notice is a legally significant choice. We would not want you to be in a position of having to give legal advice. So we would strongly encourage you to send them to the claims administrator's website. That's realestatecommissionlitigation.com. That link is available on facts.realtor as well. And I'll drop it in the chat, and I'll share it with Mark in a subsequent email so that he has it as well. So direct them there. There's a phone number and an email address they can call and contact with questions and lots more information. Direct them there. Don't try to answer their questions, because you could be giving them legal advice. Just a couple of resources, because as I mentioned, we are committed to continuing to make sure that you all can navigate this. So the ABR designation, the Accredited Buyer Representative designation, if you have not already taken this, this is a fantastic course. All of the material has been updated consistent with the practice changes. It's usually a $295 value. NAR is offering it to all members for free this year.
Hey, Matt,
Yes.
I'll be teaching it. I'll be teaching it for all of Fathom Realty's Region 3, October 7th and 8th, or 8th and 9th. But it will be available. Plus, I'll probably be doing one locally before the end of the year here for my agents.
That is fantastic. Thank you so much for doing that and for sharing. We appreciate it. And you're going to be learning from the best. And really, this course does really focus on conveying your value proposition, going through the buyer counseling session, explaining to buyers why the written buyer agreement requirement, why it's in their best interest, helping them through the search, showing, and selection process, and how to legally and ethically negotiate client offers to make sure they get the representation that they want, that they can also afford, that's consistent with their finances and their financing. I've mentioned it before, but check out facts.realtor. There are hundreds of FAQs. There are videos. There are summaries of the policy changes. If you want some light bedtime reading, there's a copy of the settlement agreement itself. There are broker resources. There's just tons of information on there. Lots of things that you can also provide to consumers if they're asking you questions. We've got the Written Buyer Agreements 101, Broker to Broker Agreements 101. We've got videos. I think there's a couple featuring yours truly. And we encourage you to check it out frequently too, because we're constantly updating it. I literally write some of these materials, and I check it every day just to make sure I know what we've posted recently. So with that, Mark, unless you had anything that you wanted to kick off, I'm happy to start going into some questions.
Let
Okay,
me
I do
go
see
ahead
some.
and end the
Yep.
recording, and then we'll go from there. So let me do that. And thanks, Matt. I appreciate the great presentation. So for everybody else, let's go ahead and hold off on questions until I give you the go ahead. Everybody that is receiving this video, thank you for watching the video, and for Matt Troiani coming and doing that for my agents and anybody else that sees this on through YouTube. Thank you.